Good morning, good afternoon and good night learners. Let's learn the law, civil justice and tort law. Unit 2 The civil court system and civil justice. As you learned in Unit 1, civil claims concern a wide variety of issues such as negligence claims, consumer law, family issues, employment problems and housing matters. This unit explores the civil justice system by considering the challenges faced by modern civil justice systems, considering which people or bodies are best placed to resolve disputes between individuals, contrasting the justice systems in England and Wales, courts led by judges and tribunals, with civil justice systems in other countries, courts with juries and community leaders. Introducing the classification of the civil courts in England and Wales and the governing procedures. Considering the outcomes of civil court trials and the appeals process. Exploring the new possibilities that have been created by modern technology. The challenge for a modern civil justice system. There are many debates about how much public money should be spent on the legal system. One of the main challenges for the civil court system in the 21st century is to achieve a balance between the requirements of efficiency, trying to control costs, and achieving fair outcomes for individuals which uphold their legal rights and responsibilities. The civil justice system functions to resolve disputes between people peacefully and in a way which is perceived as being fair, according to law. This can involve compensating the party that appears to have suffered loss or is disadvantaged. As a result of the growth in the number of laws and increasing complexity of society, most people will now seek some form of legal advice during their lifetime, whether it will be to purchase a house, resolve family issues, seek advice about debt, make a legal claim, or obtain advice on tax or income issues. Where these issues cannot be agreed, they will need to be resolved through the civil justice system. To do this fairly, civil justice needs to be accessible to individuals and it needs to be open, or transparent. Transparency means that justice is seen to be done. Who should decide civil disputes? In England and Wales, it is accepted that disputes between individuals should be resolved through the court system, with a judge deciding the case on the basis of the rights and responsibilities owed by each party. However, this is not the case in some other countries. In other civil justice systems, other organizations and people have responsibility for resolving disagreements between individuals. The vast majority of civil cases tried in court in England and Wales do not have a jury. Libel and slander trials are the main exceptions, and the judge hears them on his or her own. Before trying a civil case, the judge reads the relevant case papers and becomes familiar with their details. Judges play an active role in managing civil cases once they have started, helping to ensure they proceed as quickly and efficiently as possible. This includes encouraging the parties to cooperate with each other in the conduct of the case, adjourning proceedings and asking the parties to go outside the courtroom to try and settle the case through negotiation, encouraging the parties to use an alternative dispute resolution procedure if appropriate, controlling the progress of the case. Occasionally, the parties will have agreed the relevant facts and it will not be necessary for the judge to hear any evidence. The issues may concern the law to be applied or the terms of the judgment to be given. Often, written and live evidence will be given by the parties and their witnesses and they may be cross-examined. The judge ensures that all parties involved are given the opportunity to have their case presented and considered as fully and fairly as possible. During the case, the judge will ask questions on any point they feel needs clarification. The judge also decides on all matters of procedure which may arise during a hearing. Once the judge has heard the evidence from all parties involved and any submissions, representations, they wish to put forward, he or she delivers a judgment. This may be immediately, or if the case is complicated, at a later date. This is called reserving judgment. The judge will decide the outcome of the case by finding facts, applying the relevant law to them, and deciding on any remedy, if the case is successful. In Unit 3 this process is studied in more depth. Civil judges do have the power to punish parties if, for example, they are in contempt of court, i.e., deliberately failing to obey or respect the authority of the court, but, generally, civil cases do not involve the imposition of any punishment. Civil cases heard by juries. As already noted, in England and Wales civil cases are generally decided by a judge alone who will decide on the facts and apply the law to them. However, this is not the only way a civil justice system can operate. For example, in the United States there is a right to trial by jury in federal civil cases, protected by the 7th Amendment to the U.S. Constitution. You may already be familiar with the use of juries in civil cases through popular books about American courtroom dramas written by novelists such as John Grisham. In civil jury trials, the jury will decide on the facts, come to a decision, and determine the amount of damages or compensation a successful party receives. John Paul Ryan has written a book about American trial judges, and he compares the advantages and disadvantages of jury trials as follows. Americans today value the many positive virtues of our jury system. The jury helps to sustain democratic values. The jury is a key part of the due process protections guaranteed by the Bill of Rights. The jury is the guardian of the public trust and the voice of the community's values inside a legal system dominated by lawyers and judges. Yet we also hear many criticisms about juries in practice. Juries are biased. Juries disregard the judge's instructions or the law itself when reaching a verdict. Juries know too much about a case from media publicity to be able to render a fair judgment, or juries know too little and are unable to comprehend the issues in complex cases. Finally, too many Americans shrink from their civic duty by seeking to avoid jury service. Tribunals. Some types of civil disputes in England and Wales can also be resolved by tribunals. The tribunal system operates separately to the courts, although there can be appeals from upper tribunals to a court. There are increasing numbers of cases heard within the tribunal system. As such, the tribunal system is important in providing civil justice. Tribunals are established by statute to deal with specific types of claim. A significant difference between tribunals and courts is that the persons making rulings in a tribunal include not only a legally qualified judge but also laypeople with practical expertise on the type of cases that are brought before it. Prior to the coming into force of the Tribunals, Courts and Enforcement Act 2007, there were a large number of different tribunals covering a variety of subject areas of dispute, such as employment, social security, and mental health. The 2007 Act introduced a new unified tribunal structure. The Act combined most of the former tribunals into what are called first-tier tribunals. Above the first-tier tribunals in the hierarchy, the Act created upper tribunals to hear appeals on points of law from decisions of a first-tier tribunal. Employment tribunals remain outside the new tribunal system. They have jurisdiction to hear disputes in an employment context, such as unfair dismissal claims and claims relating to discrimination in the workplace. There is a right of appeal on points of law to the Employment Appeal Tribunal and then, if leave to do so is given, to the Court of Appeal. Appeal from the Court of Appeal is to the Supreme Court. Customary law and community leaders. Some countries have customary law as part of their legal system, notably in the Pacific Islands and Africa. As the term implies, customary law is based upon the customs of a community. Common attributes of customary legal systems are that laws may not be written down, they are an organized set of rules regulating social relations, and they are agreed upon by members of the community, CIA, N.D. Closing parenthesis. In these countries, civil disputes may be resolved by community leaders. In the UK, along with Europe and North America, the law governing civil disputes is based on the idea of individual rights and individual ownership of property. This is reinforced by international human rights treaties which set out the individual rights and freedoms enjoyed by citizens. However, in other places, the emphasis is placed upon the collective or communal rights and the need to preserve the relationships between individuals, families, and the community. In collaborative or communal systems, a community leader works with the parties in a cooperative way to resolve disputes which might allow contributions of ideas and evidence from persons not parties to the dispute. For example, ownership of land and the accompanying rights and power is largely determined by tradition and custom in the South Pacific, not by property law as commonly understood in the West. Traditional practices encourage disputants to settle their differences through a process of acknowledgement and forgiveness rather than through a legal remedy or sentence. Klingelhofer and Robinson, 2001. The civil court system in England and Wales. As you have learned, in England and Wales civil disputes that cannot be settled between the parties are resolved in either courts or tribunals. Within the civil court system there are rules and procedures aimed at ensuring civil justice is provided. The tribunals are less formal but have similar goals in their procedures. In England and Wales, most civil disputes are first heard in the county court and, in the case of more high monetary value or legally complex cases, the High Court. The types of cases to come before civil courts cover a wide range from small claims to large claims. Examples of simple claims are claims for recovery of small debts. Large claims could be claims about a sum owed between multinational companies. Hearings are usually in open court, meaning the public may attend. Some hearings, such as family hearings, are in a judge's private room from which the public are excluded. Other matters are decided by the judge in private in the presence of the parties, without witnesses giving oral evidence and based on documents alone. In court proceedings, the aim is to make it as simple as possible for the parties to understand the process and feel that their case has been dealt with fairly. As such, civil courts have a set procedure which must be followed. Since 1999, the rules and procedures for all civil courts, except the Court of Appeal and Supreme Court, are set out in the Civil Procedure Rules, the CPR. One of their aims is to ensure that all cases are dealt with justly and at proportionate cost, so far as is possible. They require parties to be open and to cooperate in the resolution of their dispute from the outset, including using alternative dispute resolution procedures, ADR, such as arbitration, mediation, and negotiation. Classification of courts. In order to consider how civil disputes are resolved, it is important to understand how courts are organized and classified. There are several ways in which courts can be classified. They can be classified as trial courts or appellate courts, or according to their hierarchy in the court structure. Trial and appellate courts. The function of a trial court, such as a county court, is to hear cases in the first instance, that is to hear the case for the first time, make a ruling on the issues of fact and law that arise in the case, and give a ruling. The High Court, County Court and Family Court are trial courts, along with the Magistrates' Court, which has some jurisdiction in the civil law system. Appellate courts, on the other hand, usually only reconsider the correctness of the application of legal principles to a case that has already been heard by a lower court when it is appealed. However, in some instances appellate courts have jurisdiction to reconsider disputed issues of facts, i.e., disputes about events leading to the legal action. In civil courts, the High Court, Court of Appeal and Supreme Court are appellate courts. This might appear confusing as trial and appellate functions are combined within one court within the hierarchy, such as the High Court. Court hierarchy. Superior courts have unlimited jurisdiction, both geographically and financially, and, broadly speaking, try the more important and difficult cases. Inferior courts have a limited jurisdiction substantively, geographically, and financially. They deal with less difficult cases and are subject to the supervisory jurisdiction of the High Court. However, it is misleading to think of inferior courts as unimportant. Only a tiny proportion of legal cases are dealt with by the superior courts. Judgments in civil claims. A judgment is the decision the judge makes at the end of the hearing in order to resolve the dispute in favor of, or partly in favor of, one of the parties. It contains the legal principle applied to the dispute, by way of justification. The judgment usually ends by setting out the legal remedy, when the court favors the claimant, in the form of an order. If the defendant wins, then the order will be along the lines of case dismissed. The task of the judge is to decide what the appropriate remedy is, if any, and on its precise terms. The decision the judge makes must be based on the correct application of the law and understanding of the facts. Civil courts hear disputes about many different things. Usually the outcome for a successful claim is money or damages to compensate the individual for the loss they have suffered. However, there may be other possible outcomes. For example, the claimant may have asked for an injunction to forbid the defendant from making excessive noise by playing drums in the flat upstairs in the early hours of the morning, or a declaration such as an order specifying the precise boundary between two properties about which the parties had never been able to agree. Sometimes it is not possible for a court to provide an outcome which will remedy the issue complained about. For example, a person who has life-changing injuries as a result of negligence from an employer or other person will be helped by an award of damages, as this will compensate them for things such as a loss of earnings or specialist equipment they may need to be able to live independently. However, money cannot remove the permanent injuries or disabilities they now suffer from. Appealing. There is a strong public interest in the finality of judicial decisions on civil claims. An open-ended appeal system, whereby parties could appeal any decision, would undermine this by encouraging litigants to continually challenge decisions. It is therefore important for the appeal system to strike a balance between encouraging finality on the one hand and correcting mistakes on the other. This is reflected in the limited grounds of appeal. An appeal is usually only allowed if the decision was wrong, which means unsustainable in fact or law, or unjust because of a serious procedural or other irregularity in the proceedings. Parties cannot appeal simply because they feel another court might be more sympathetic to their case. Put simply, if an appellant asserts there is something wrong with a judge's ruling or judgment, they may appeal to the next higher court in the court ranking. See Figure 9 in Section 5. 1. Asking the higher court to make a different ruling or judgment. However, in some situations this normal route may be diverted from. For example, if an appeal raises an important point of principle or practice, or there are some other compelling reason, it may go direct to the Court of Appeal, or if it's from the High Court, direct to the Supreme Court. The appellate court hears the arguments, submissions, of both parties. It does not rehear the case with witnesses. The appellate court can either uphold, reverse, or overrule the decision appealed on from the court below, or even depart from it. A case which is either reversed or overruled loses its authority. The Supreme Court. The Supreme Court is the highest court in the United Kingdom. It was established by the Constitutional Reform Act 2005, replacing the judicial function of the House of Lords. The Supreme Court is the final court of appeal for all civil cases from England and Wales, and also for Northern Ireland and Scotland. The Supreme Court also hears cases on devolution matters under the Northern Ireland Act 1998, the Scotland Act 1998 and the Government of Wales Act 2006, as amended by the Wales Act 2017. In most instances the highest appeal court is the Supreme Court. Where those human rights set out in the ECHR are involved, it may be possible to appeal to the ECTHR. The Supreme Court hears fewer than 100 appeals a year. It does not deal with the facts of cases and does not hear witnesses. Under a practice direction made by the Supreme Court's predecessor, the court is not bound by its own previous decisions. This will be discussed in detail in Unit 4, but in practice will usually follow them. However, it does have to take regard of a decision of the ECTHR. The Supreme Court is located in Parliament Square, opposite the Houses of Parliament in London. The building was formerly the Middlesex Guildhall, the European Court of Human Rights. In limited circumstances it is possible that the final hearing of a claim is not in the Supreme Court. When rights established in the ECHR are alleged to have been violated, individuals may apply to have their case heard by the ECTHR, sitting in Strasbourg. This court rules on breaches by states of ECHR rights. Judges are appointed from each state which is party to the ECHR. In 2020 there were approximately 62,000 applications pending and 39,190 decisions or judgments made by the ECTHR. Claims, petitions, are made against a state, not individuals. Therefore, someone who claims their human rights have been breached in the UK will bring their case against the UK government. The use of modern technology in civil justice. In 2016, Lord Justice Briggs set out his proposals for modernising the civil courts and tribunals in England and Wales. His vision was the creation of an online court, which would resolve some civil cases up the value of £25,000 entirely online. It was a radical proposal, and although the online court has not yet materialised, there is a £1 billion court reform project in progress to digitise the civil justice system. Progress has been slower than planned because of the complexities of the project and because of issues related to the COVID-19 pandemic. Nevertheless, there is a drive from Home Courts and Tribunal Services, HMCTS, to transform and modernise the court system through the introduction of digital courts. Although there is not yet an online court, there have been significant changes to the ways in which civil, family and probate cases are now dealt with. Money Claims Online, MCOL. MCOL is an online portal that allows a claimant to bring a claim in the county court for a specified amount of money that is less than £100,000. It offers a simplified online process for a litigant to issue a claim through MCOL. Once the claim has been issued, the defendant responds to the claim online. If the defendant admits the claim, the claimant can apply for judgment online and the defendant can make a payment online. If the defendant defends the claim, then the case is moved to a local county court hearing centre. During the COVID-19 pandemic from 2020 onwards, many courts closed and there were significant delays and backlogs in resolving disputes. However, because MCOL is an online portal, claims could still be issued, and arguably this meant that access to justice continued during this difficult time. Online Civil Money Claims, OCMC, pilot. The OCMC pilot started in 2017 and is due to end in 2021. It has been hailed as the nearest thing to the vision of the online court. This pilot allows claimants who do not have legal representation to issue a civil claim for a specified amount of money up to £10,000, which would normally be dealt with through MCOL. What is different about this service is that the technology to offer a full end-to-end online process is being developed. It is hoped that when the OCMC service is fully operationalized, disputed cases will be resolved by the judge looking at the digital papers, file, or by virtual hearings. The online service is available anytime, 365 days of the year. There are also other online legal services being piloted and developed. Personal injury claims, divorce, probate, social security, child support. Advantages of digitalizing civil cases. There are a number of advantages of moving to digital courts. For example, the process for a divorce online is quicker than if you apply by post. Digital courts allow for some cases to be resolved without the parties needing to attend court, which can make the process more accessible and less intimidating. New online legal services are being designed to be more straightforward, so the system can ask a series of questions online to help users complete court documents and agree settlements. The use of technology has the potential to save time and money and reduce the administrative burden on the court service. It also provides an opportunity to improve access to justice for ordinary people. The process of bringing a civil claim for many people who are not represented is daunting. If legal disputes could be resolved through negotiation and online hearings, it may encourage more people to enforce their legal rights. The pandemic may have accelerated the process to digitalize civil claims, and in the next few years it is likely that there will be more cases being dealt with online and more court hearings taking place remotely. There is a recognition that the court services need to be modernized, but the increased use of technology is not without risks, and it is critical that we get the transition to digitalization right. Virtual hearings. Virtual hearings take place via telephone or video conference, and have been a feature of the civil justice system for many years. However, the COVID-19 pandemic accelerated the use of remote hearings, not just in England and Wales but across the world. Prior to the pandemic, the court service in England and Wales used the cloud video platform, CVP, in criminal courts. The CVP uses a secure web browser and is accessible by mobile devices. In July 2020, the CVP platform was extended to include civil and family courts. Advantages of remote hearings. As you have learned, the Supreme Court and all courts have had to make some significant adjustments to allow them to continue to hear cases during the COVID-19 pandemic. It is predicted that remote hearings are going to become an integral part of the way in which cases are heard and resolved. The advantages of remote hearings are that participants save travel time and cost. Legal representatives can cover more courts from a single place. More efficient use of time. If a hearing is delayed, the participants can do something other than waiting in court. Court cases can be cheaper because you do not have to pay for expert witnesses' travel and waiting time. Participants, for example parents in family cases, are more able to join a remote hearing because they have less issues with having to find childcare. Participants may find the process less intimidating than attending an in-person hearing. Challenges of remote hearings. However, although there may be practical benefits for participants attending virtual hearings, there are some concerns about the use of remote hearings. Participation in remote hearings is dependent on having access to technology and a good quality connection. If there are technical issues in a hearing with participants dropping in and out, it delays the hearing and makes the process very stressful. Many participants may only be able to access the hearing via their smartphone. If they are being legally represented, it makes it very difficult to also communicate with their legal representative during the hearing. Lawyers acting in remote hearings have the challenge of often using several screens, one for the evidence, one for the hearing, and another device to connect with their client. It is often more challenging and slower to cross-examine witnesses remotely. It is important that participants can actively engage in the court process, and if remote hearings are seen as a poor substitute for a face-to-face hearing, it may undermine the justice system. Digital exclusion. Although there is potential for virtual courts to bring benefits, it is also important to consider how to ensure that people who are on a low income and are more vulnerable do not become excluded from the justice system. As more and more civil legal services are digitized, we have to consider the risk of digital exclusion on the rule of law. It is essential for access to justice that people are not left behind and are able to meaningfully engage in the civil justice system. This unit explored the civil justice system. It started by considering the challenges faced by modern civil justice systems and the different people or bodies who resolve civil disputes across the world. The unit then focused on the civil justice system within England and Wales. The unit explained the classification of civil courts and tribunals, the judgments made by civil courts, and the appeals process. The impact of technology on the civil justice system was also discussed, along with the skill of essay writing. You should now be able to Explain the purpose of the civil justice system. Understand some of the key challenges faced by the civil justice system. Outline the civil court system including its classification, judgments, and appeals processes. Understand how technology is impacting on the civil justice system. Please like, comment and subscribe. Good morning, good afternoon and good night learners.